Okay, this is lecture 3, um, judicial process. I want to start by talking about one of the most important sort of concerns that we have when we talk about the process. In terms of what area can really move things in a certain direction that we may not want. Because you have to understand that, and we get to the rule of law later on, that there has to be a level playing field in terms of people having access to those things which would allow them to increase their own wealth or their own opportunities. And one of the things that's problematic for a couple of reasons is this idea centered around antitrust law, right? The whole point of antitrust, and really there's two types that we look at. One's horizontal and one is vertical. But the idea of antitrust is corporations or entities, but typically corporations, capturing a market or controlling that market in some way, typically because they have access to all kinds of resources. So think about Amazon. There's really not a competitor for Amazon. Amazon pretty much has all products, but its function is just to sell those products. And so it doesn't really, it's not necessarily monopolizing in terms of an industry, because all products are there, but rather in delivery of products to people. So the horizontal integration is what we're more worried about. The vertical integration is different. So vertical integration simply means that a company says, we should buy this other company or join the two companies because in the development of the product, the other company is an important piece of that. And so there are benefits to bringing them together, but it doesn't have, other than an efficiency, doesn't have much impact on the market. Again, other than efficiency, maybe that drives down the price or whatever. But there's a whole division in the Department of Justice that focuses on this, and it's an important part of the process because I think you can make a very solid argument that it's the antitrust division doesn't have a lot of resources, and I'll give you some of those, and doesn't really, even though there's lots of lawyers, typically it's about a penalty of some kind, but the corporation can make more money. I touched on that with the oil spill in BP in another lecture. But the point here is that vertical integration simply means trying to be more efficient by bringing in and joining with a company that is in another part of the development of that product. So in other words, the actual corporation may make bowls, but there's another company that makes spoons. So it might make sense to join those two to keep costs down. And so that's not so problematic in terms of controlling the market. It's horizontal integration in terms of antitrust that's problematic, because horizontal integration means that you've got one company buying another company, right, doing the same thing as a means of joining them. And yes, there may be a component part that is, lowers the cost factors, but they're capturing a market. And that's problematic, and this is not an economics class, but for many reasons, including monopolizing that market and controlling it. So you get what we call, profits above, or monopoly profits above what we normally get, and you get inferior products because they control that market. There's no competition, and competition is key in all of this. If you think about the rule of law, as we'll discuss later, there's really competing interests, and you need to be able to govern those things effectively. So what happens when we have this this horizontal integration? The thing we worry about is really, and I've touched on this idea of negative externalities, that basically what we're going to have is, a product or consumption of a good or service has a negative effect right on a third independent party. So again, I mentioned this before. If you're dumping polluted water into, a stream, then that's an externality, a negative one. But I just wanted to go through the idea here of the Department of Justice just to give you a sense of this. The U.S. Government's expenditures are in the trillions of dollars. So some of these numbers seem very big to us. But relatively speaking, for example, if you look at the Department of Health and Human Services, they have the biggest budget. And this is for 2023. This is the projected budget. So and I mentioned before, you ask for money, but you never want to not use all the money in your budget because then you get cuts. So everyone is always increasing. It might be small, but they're increasing administrators and the like, the money they owe. So if you look at moving down, you've got Social Security Administration second, Department of Defense and Military Programs is third, Department of the Treasury is fourth, Department of Veterans Affairs is fifth, Department of Agriculture. By the way, the first three, Department of Health and Human Services, Social Security, and Department of Defense. Department of Treasury, okay, we'll throw that one in. They have rather large budgets. It really pares down as you go down the list here. Department of Education, almost nothing. Department of Transportation, Office of Personnel Management, Social Security Administration, Department of Homeland Security, Department of Labor, other defense and civil programs, Department of Housing, Department of Energy, and now we get to the Department of Justice. Now, keep in mind, that's the budget this is going to be the budget for the entire, and again, it sounds like an awful lot. You talk about 43.5 billion or whatever. It seems like a lot of money. But when you talk about the Department of, Health and Human Services, we're talking about 1.6, trillion or thereabouts. So that really moves. You can see that there's not a whole lot of money there. Now within the Department of Justice, right? There's the Antitrust Division, and the Antitrust Division really doesn't get a whole lot of that money. They get in 2021, for example, it was $184.5 million. There were 740 administrators or positions, and there were 363 attorneys. So that keeps growing. The change from 2021 to 2022 was plus 16.7 billion, and they added on 90 positions and 45 attorneys just in that one shot. So look, if you're looking for antitrust, which is pre-merger filing and collection fees and all of that, the bottom line is that they really need antitrust. But again, it's a very small part of the Department of Justice. And I know it seems like a lot of money and there's a lot of personnel. But think about it. You've got those attorneys handling the entire country. And it's more complicated than that. So any discussion then of, the process, it's interesting because you have to adjust for those things. So why is that important? Because when you think about due process, the rule of law, which we get to, one of the important areas to control is this corporate sort of movement, to capture markets. It's dangerous because once you capture a market, it's pretty hard for anyone else to get in. So the question then becomes, when you think about it, is what do we think about this whole idea of liberty? Because look, at the end of the day, processes and procedures serve a goal, right? And in the case of when we talk about, these ideas of, general welfare and the like, there's a goal. And is the goal being met or is it being distorted? Because you'll see, again, with the rule of law, the key thing here is separating the political realm from the judicial realm. In other words, the judicial process should be really free of political influence, and you'll see why later on. It's obviously not, and it really should be. And so anyway, there are any number of approaches here, about liberty by Hegel and by Rousseau and by Locke and by people like that, Bentham and Marx. And the reason is very simple. They're trying to figure out and take a look at why it is that, what should liberty be, and why that's important to a state. Okay, so what they're looking at is, what's the state's job in protecting and, having a process for perpetuating the largest and most complete, structure in terms of liberty. That's what we're interested in. What is the state's job? Again, the rule of law is key when we get there. But what's the state's job? We have to get our minds around it. And there is this idea, with Rousseau especially, about general will of the governed. The idea, and there have been others that have been writing about this for a long time, some very practical and looking at, okay, what are the consequences of a state not really doing its job or allowing the accumulation of wealth, which is what we're concerned with here. That's the idea of the antitrust stuff, corporate level. But we know we have people, Jeff Bezos and others, that have accumulated large amounts of wealth. But eventually, if you eat out the sustenance of people in the middle class, those are the people that buy your goods and services. Think about Amazon. If Amazon got to the point in others where not enough people were working, they couldn't sell the products. No one's there to buy it. And so there's a value in making sure that you sustain this general will of the governed. In other words, the state respects that and does not do things like eat out the sustenance of the middle class, who's primarily responsible for the purchase of goods and services, right? There are so many others. Hegel, the idea that, the sphere of liberty as whole state with freedom, not so much individuals' rights, but a result of human reason, which falls right into this idea of judicial process. So freedom for Hegel was not the capacity to do as one liked. You could do whatever you want. Everyone was totally free. But was this alignment? Alignment where? With a universal will toward what? Toward well-being. That's the point. So the focus there again is people, and that they must be met. You look at Bentham and Marx. Now you see, that there's a bit of a change, because the idea is utilitarianism. Again, we've mentioned that before. And who has control over the mechanisms of commerce? The production. Who owns the private resources that are necessary to produce goods? Are they held by the general public? Which doesn't make any sense. It really can't be. But the government can claim, all these products and the like, and these kind of belong to everyone, the means of production, and you can't trust politicians. So now we have stepping in those that are going to oversee, right, that because they own the, means of production, that it's fair because they're representing all the people. Of course, we know that's not the way it works. You still have everything flowing up to the top, to the elites. In every culture, there are the elites, and they accumulate the wealth. There used to be a compact going way back in this country that, okay, the elites are going to do really well, but they can't eat out the sustenance of those that fight the wars, do the dirty jobs, do all of that. I once heard it said, and I think this is pretty interesting, that the difference between the classes is who showers, in the morning and who showers when they get home from work. In other words, if you're doing a tough job and you get dirty doing it and all this stuff, you kind of get home and you shower up. Those that are going to offices or going to someplace where there's a lot of just corporate stuff, they shower in the morning to get ready to go to work. Now, who showers when is not the point. The point is that there's a disparity between those that go and do those difficult jobs and those that are just getting money from doing it. Now, the culture here is such, which is interesting, that the Americans tend to believe that those people who have made a great deal of money, that those people are should be making decisions because somehow they're smarter or better. You hear the saying, well, you're so smart, smarter than this other person, but why aren't you rich? So that's the standard in America. It's like, how much are you worth? If you're worth a lot, somehow that means that you're smarter. And the second piece of that is the argument is always that, these people create jobs. But are they good paying jobs or are they not good paying jobs? Because if people are working and they're barely getting by, then it's problematic. So I'll say something that's a bit controversial, but I think it's in terms of the economic structure, which is really important for the well-being of the country, right? The economic structure is what determines what is and what is not, acceptable, in terms of, a structure of government that's supposed to be there to protect people and the like. All right. So the realist criticism of these guys, skeptics, they basically, represent a very different kind of analysis, right? Many of which contradict one another. And it's difficult to present skeptics' views as a consistent whole. What's the state's job? And to get into something more controversial, there is always an economic, approach, benefit, whatever, to any kind of economic activity. So let's think about the women's movement and women's rights. It was the case at one point, right, where men went to work, women stayed home. With the women's movement, women also moved into the sphere of working and creating wealth for themselves and so on. That's a good thing. But also, there's a fundamental piece here. When you increase the number of workers, you decrease the salary. It's supply and demand. If I'm the only worker, if I'm the only professor in the country, I can ask a lot of money in order to go to some institution and teach. Or there are just fewer of us. One is just ridiculous, but imagine fewer of us. Now imagine there were 10 times the number of professors. The income offered would go down. It's just like if everybody wants bubble gum. Everyone wants that gum, the price goes up. So the more demand you have, so the more people you have with money that can demand, the higher the price. So it's the same thing with labor. When you think about it, women that entered the workforce created more laborers on all levels. That meant the competition was such that you could lower the wage you were paying. Remember, you're selling your labor. And so if a lot of people are willing to sell their labor, then, the price of labor is going to come down. So what's interesting is now you have two members of a family, say a husband and a wife, however that gets structured, it doesn't matter. It could be, two men, two women, it doesn't matter. A family unit of some kind. Now you have more and more a situation where both people are working. And here's the interesting part. They're working, but they're not able to buy the same things that, say, their grandparents were. There's inflation, right? We look at a basket of goods. Goes way back. How can we compare the dollar today to the dollar, 50 years ago? Well, we see what, people make and what they can buy. And so there's a basket of goods that are consistent. Washing machines. Everybody needs a washing machine or whatever. So Now it turns out you need two people to purchase that washing machine as well as other things, where your grandfather, because it wasn't a grandmother in the workforce, could buy that machine, that basket of goods on their salary. So now it takes a salary of two to actually live in a condition that is not as prosperous as the grandparents. So you don't have the development and the movement forward economically. So the women's movement was great, but it puts more workers in looking for employment. That drives down the cost of wages. So here again, you have a good thing, right? But it turns into an economic challenge, right? And in order to change that, you would need people to leave the workforce, and so the cost of everyone's labor that's left would go up. So it doesn't happen, but it's almost from an economic point of view. If you get half the workers or a third of the workers out of the marketplace, then you're going to have to pay more. But if there's a lot of people that come into the marketplace, that goes down. So if you have a lot of people that want to come into the country, and you're increasing the number of people that will sell their labor, and that means that the cost of labor should go down, and that means their ability to purchase goods and services is not as great. So they don't do as well. So they're basically suffering the consequences of their own desire to work. And a movement like the women's movement, good thing, right? But even there, it has a positive effect on the elites, but a negative effect on individuals. Okay, so the organization of the judicial process is basically to deal with in an extra political way, outside of the political realm, those things, as you'll see with the rule of law, those things which are important for the functioning of the society, right? And for there to be a free state. Now, you can't have that without some sort of structure in place. And that's going to be, some sort of state, involvement in the structure and keeping that structure consistent. And that's really important. So the court structure is so important because it's outside the realm of politics. Once you get it so it's inside the realm of politics, what you get is a corruption of the process. Why? Because politicians and their goals in the structure of a state are very different than those that we find in the judicial part of the structure. In other words, in the judicial part of the state, you have a very different structure to dealing with things, and it's outside the political realm because the political realm, I hate to use the word, but pollutes that process. Once you politicize the court structure, you don't really have the same state anymore, right? When you don't have the different divisions, right, with executive, legislative, judicial, respecting each other. The president doesn't care because they're the executive; they execute the laws. Doesn't care under common law, which is decisions judges make. Doesn't enforce them because the court has no way of enforcing it themselves. That's not what they do. They lose some of their authority and power, and when they lose their authority and power, the court, there's no point to it. It becomes problematic. They need to be outside that process. We create a process here where some judges get elected, but those that are appointed, they have lifetime appointments, and it takes an impeachment process in order to remove them. And all of that's happened with justices. It's not something that we want to see a lot of because it interferes politically. So keep in mind that there are certain things that are special about this exception, this movement away from the political realm. So, for example, Judges, they're expected to do what? Approach each case with an open mind. They're not to be involved in the case, right, in any way. They lack authority to initiate the proceedings. That's on the executive side for the most part. So keep in mind that if you change that, you've changed the application and the structure, you're also affecting the outcome of cases, and the public, because they know it's political, begins to lose confidence. And as Hegel and others have said, you need that public confidence in order for the system to be legitimate and actually lead to this rule of law that's supposed to be effective. And you'll see how that sort of gets manipulated and the like. So when we look at the system, it's supposed to be impartial. And politics is anything but impartial. And so what do you have? You have a situation where you just have one political system. You have a political system where the judiciary is minimized, the legislative body is certainly more powerful, and the executive, through executive orders and things like that, can manipulate that process. In the end, the lack of support for the state, because the ideas behind the judicial process and what judges do and what courts do has been manipulated by the political structure. And that's really dangerous, because what happens is you lose that independence and you lose the faith that people have in those institutions. So, perhaps the most important single formal requirement in making these judicial decisions is that they're based on reason, not on political considerations. They're based on reasons. And that all decisions makers, right, are expected to do what? Act on the basis of what the information is, the best information they have, to make decisions based on rules of logic and rationality. In other words, no political consideration. Judges are removed. They look at the situation. They look at what is reasonable, logical, rational, and they make a decision based on that. But here, no other political actors are expected to perform solely in terms of reasoned argument, certainly not politicians. Politicians sort of stir the passions and get people to move in one direction or another, because most people really, their political party, is a cue giver. If you're a Democrat, what the Democratic Party does, you love. If you're a Republican, same thing. You don't have a lot of free thinkers in that process. You have, determination being made by really partisans, and that's politicized. Partisans are always politicized. That's why they're, partisans. So the legislative process, what does that do? It provides for an infusion of knowledge, which we like, and argument into the proceedings, right? And the legislature's decisions are not without some sort of reason. They have to at least approach that. But the ultimate outcomes, are about political power, the desire and the want for political power. But the legislative bodies and those that are political by nature can't ignore the fact that the judicial process exists, right? That it was deliberately created, specifically designed to reduce what? The impact of political forces and to maximize evidence and reasoned choice. Now, evidence and reasoned choice are important because the public can understand how the courts got there. What do they consider? What was going through their mind? Whether they accept it or not, they understand how the courts reasoned it. And so it's not like the legislative branch just does what it wants to do. It has to at least give a nod to this judicial process, at least consider the judicial process. That's why it's so dangerous when politicians point out, say, a justice, and say that justice, because they voted a certain way, that we shouldn't accept that. right? And what you see most recently, protests outside the homes of justices never happened. It's unacceptable because they need to be free from that sort of influence politically, right? And so judges need to be separate from that process. So the idea is that the judicial process does make it possible. It does make it possible for interests that lack large numbers of voters or controlling legislative representation to win a favorable decision. In other words, staying away from the political structure allows the justices to make a decision based on reason, and they're not tied to what the general public wants, but the minority voice, the numeric minority voice, gets to be heard. The judicial impartiality between immediate parties to a lawsuit, right, is obviously required if the judges are able to function as outside the dispute. In other words, a justice that can't operate outside of the dispute is one who's involved in the dispute. Typically, they'll recuse themselves if there's any conflict, because that conflict casts doubt on the decision the court is making, because the court itself is influenced by the political structure. So the desirability then of securing judicial impartiality, neutrality between and even-handed treatment of all parties is critical for what? It's critical for the judicial process and judicial members of that, especially judges. It's important that the people accept decisions and have faith in that process. And again, that process begins to break down when you have political influence. And recently, there's been an awful lot of attempts at influencing the court. What about judicial rulings as political forces? A judicial opinion justifying a decision, and that's what they must do, especially of appellate court. There's court of first instance, and then there's the appellate court. Really, no one has a right to expect that the Supreme Court is going to hear a case. But you got one shot at it with the appellate court. So the appellate court itself becomes a factor in the political process. The opinion is both an explanation of a particular decision, because they write out their thinking, right? They don't just make a decision that's not exactly true. In some cases, they just do without writing anything. And those are special cases, that make sense. Sometimes, given the particulars, and that's beyond the scope of the course here. So for the opinion that they're writing, right, is both an explanation of a particular decision and instruction to law officers, including subordinate judges and the like, as to how they should dispose of similar disputes. It's like, this is how we view them. So the appellate court is saying that to the court of first instance. In the federal system, district courts or whatever, and the Supreme Court hears that they're really taking it to the appellate court. And these opinions, like statutes, are themselves subject to a variety of constructions, interpretations. So common law really is about judicial decisions that some people argue create law. Okay, so when you look at it, statutes written by legislative bodies, that's what they do, are not necessarily without their political considerations. And those that might have a dispute with it will point out those as distorting the process, right? So the validity of a norm, which is what we're looking for here, right, doesn't follow from its existence, but from the fate it suffers in the administrative and judicial process. So having a norm does not follow from just its existence. It's there, right? But rather how administrative and the judicial process interpret it. So there's a norm, but what does it mean? It's up to others to make that determination. So if you have a political system where there's some measure of stability, a judicial decision normally disposes of the dispute between the parties to the lawsuit, right? If you're going to have a political system with any measure of stability, you need a judicial decision, because they're outside the political stream, to make decisions based on not the political considerations, but the facts and so on and so forth. All right. Now, look, judges have no specific straight direct command of political or military, and I alluded to this before, force, and they really depend on the executive to enforce. So if the executive doesn't enforce, or sometimes they'll parse it. They'll take that provision of the decision and they'll enforce that. But they don't like that provision, so they won't enforce it. And the key there is kind of interesting, right? Because when you think about what they enforce and don't enforce, that could change the whole intention of the court, and it infuses a whole lot of political considerations into a court decision. And so when you think about it, if they get involved in this sort of thing, the executive branch, they're really making a determination about the decision and what needs and what needs not be executed. And presidents have sort of become aware of this. And what they've decided was that we don't have to, which is a constitutional provision, right? We don't have to veto, a law, let's say that's coming from Congress. We could just, when it comes to the courts, we'll challenge it there, and then we'll go ahead and we'll just effectively, enforce certain provisions of it that we want to enforce. And again, when you think about enforcing those various decisions, what you're really talking about is changing the substance of it. So even though there may not be any influence going into the process and during the process, it's very possible that once it's outside the process, that it could be manipulated. And again, as you'll see with the rule of law, this is really problematic because people can't depend upon the law. And when you can't depend upon the law, then there are problems. So I'll give you an example when we talk about criminal law. And we're really interested in criminal law more than civil, because criminal law obviously impacts and is affected by, the structure itself, liberty, right? Liberty and freedom are affected with criminal law. When you look at the first 10 amendments to the Constitution, majority of those, the first two give you some freedoms, and then you sort of have the rest of them talking about this process, due process. So think about how the structure of criminal law, right? There's an incident of some kind. Someone does something they shouldn't be doing. It could be anything from robbing someone, murder, whatever. And so there's an incident, and the next thing is there's a police investigation. Now, there's a couple things that can happen, right? Arrest at the scene or referral that's sent to the prosecutor's office. Prosecutors are typically political. And that means whether or not they take a case is important. They could decide not to pursue a case. Even the most egregious acts, they could decide we're not going to go ahead and prosecute this. And the choices from there are really straightforward because arrest at the scene based on the investigation and on that incident is going to go referred to a prosecutor's office who will charge or not charge. If they don't charge, it can be sent to some sort of municipal court or whatever, or not at all. If they do charge, then any number of things can happen. They can be held in jail, right? There could be a bench warrant out for them. There could be a summons served. And then all this leads to going to court now, okay? And we'll talk about these various things, what they are, and having an arraignment. And now they've been found guilty, right? Okay. At the arraignment, or they've been found, you're coming to court for the first time. The arraignment, they could say, well, there's no probable cause here, and so the court could dismiss it. If there is probable cause to believe this person did it, the court has to make a decision about no bail or bail. Or the person can be released on their own cognizance. They can be released back out into the public, and you'll see when we get to it how the determination is made or should be made. And then there are all these pretrial proceedings. Guilty plea, dismissal, the trial itself. There again, it's a not guilty or a guilty verdict. Then there's sentencing and there's an appeal and that's optional. There could be a mistrial, right, for any number of reasons, and the process begins again. Now, here's the thing. When you look at people that don't have the political resources to have the best attorneys in a criminal matter, think O.J. Simpson, fight for them and argue for them. What you're stuck with, really, is you're stuck with a public defender. Nothing wrong with a public defender, because the Constitution says you have to have legal representation. But a public defender, their caseload is tremendous. And so they have to get through things relatively quickly. So pleading the thing out, having the person, accept their guilt and say, look, you might as well plead guilty to this, because if you don't and they find you are guilty, you're going to spend more time in jail. But oftentimes what they don't realize is that once you go to jail, that stays with you. It's on your record. And employment and other things are very hard to get, or certainly harder. Hiring someone who's been arrested and spent time in jail is not something a lot of places, companies alike really want to do. And so the consequence here is really a serious one. But a lot of people, for a lot of reasons, end up in that situation. And there again, that's a corruption of the process, because the legal representation is not equal across the board. Some people, the elites, play on a different field. And there they get more consideration. Okay, so let's talk about judicial review, the purpose of that and the like. So one method for resolving these disputes over constitutional boundaries, which is now we're at the Supreme Court. When we say Constitution, we're talking about typically the set of rules, whether they're written or not, which is considered by most members of the community to define authoritatively the fundamental political relationships within that community. It sounds like a lot, but all we're really saying is that whether it's written or not, these principles are important to guide the behavior. And that's very important, as you'll see with the rule of law. So in any political system, no matter how developed or westernized that system may be, the boundary separating constitutionality, permissible behavior, right, from that which is constitutionally proscribed is imprecise, right? There's going to be occasional controversies, even with the Constitution and the presentation of that, in terms of how we interpret it and how it's presented in any given situation based on the facts that are there. So the idea of the judicial process, and when we think of constitutional provisions, is to resolve disputes. All of law is about resolving disputes. No dispute, no reason to be in court. So there are a couple of assumptions that you have to, there might be exceptions here. So first, the body exercising judicial review, the court that is, need not be an integral part at all of the ordinary system of law, right? In the United States and elsewhere. And what that means is that these exceptions, in order for this to work, mean that first, the body exercising, the courts would have judicial review, need not be an integral part of the ordinary system of law courts. You'll see the process later. What we're saying is that those that are looking at the law itself, there are these exceptions, right? Because they're outside the structure. The second assumption is that the judicial body's refusal to enforce or otherwise legitimize official conduct constitutes judicial review only when the ground for doing so is in the country's constitution, if the country's constitution has been violated. So refusing to sanction an official's conduct because it exceeds the authority delegated to him by ordinary statute or by an administrative superior, right, is not considered a species of judicial review. Okay? That's to say that when you're dealing with officials and their acts as officials, it's not considered something that is comes before the court for the court to review. And the third assumption here that we have to make is that the range of behavior that's going to be reviewed must cover national rather than regional, legislative, and executive action. The courts, Supreme Court, which is what we're most interested in because they're the final arbiters of the law, these are things they have to, the assumptions in order for the court to actually have any involvement. So, I'm not going to go on judicial review if you take common law or other related classes. There's judicial review and federalism. And here the question is, to what extent does the court play a role in dealing with the federal structure, the other two branches? Legislature, where basically they can say that the law you've written, the statute, is not constitutional, or the executive, saying the executive action taken is beyond the executive scope or what have you. So the court's involvement in that, Marbury versus Madison, is very clear that the court, if you read the decision, must have the right, because judicial review, if the court can't review the actions of the other two branches, and they can do whatever they want, then the political influence of those things go unchecked. In other words, if the court can't say your legislation is, not constitutional, then the court can, then the legislative body and the executive branch could do anything they want to do at all, and that's problematic. Think about the antitrust laws again. If the court doesn't enforce those, then what's the benefit to the the politicians doing so, right? So when you think about that merger, corporations merging vertically and horizontally, you could see that if the courts, the Department of Justice could take a corporation all the way to court, typically the thing is they want to be paid money. You broke the law, you kind of, it's antitrust, we're going to go ahead and you're going to be fined. Collection of money is important because that's how they justify their budget. We brought in so much money last year. You're paying out a lot, but it's important to protect the country from these sorts of manipulations, the marketplace, and we can charge fines. I talked about BP, and the fine that they had to pay, and how it looked like a great deal of money to the average citizen. A couple of billion looks like a lot, or 100 million, or what have you. But in essence, if the corporations are making a lot more money than that, it's actually a pretty good deal, right? In other words, the company is being punished, but not in a way that's problematic in terms of their profit. Keep in mind that companies can always increase the cost of their products, right? And that means they can always pass along, and they do, any penalty or any real difficulty. They can always pass that on to the public, and they do. And in passing it on to the public, they really eliminate their cost. So what is the cost for their behavior? Well, if they can pass it along to the general market, then that's not going to be something that will discourage them in the future from doing what they're doing. All right, what I want to do now is give a general introduction to the federal court system, so you get a sense of how this is set up and the like. It's important only because you need to know where things reside, where in the process. First of all, what's the structure of it, then what the process is, and what resides in various places in that structure. So the federal court system has three main levels. The district court, which is the trial court, a court of first instance. In other words, that's where you bring federal cases. Then there are circuit courts, which are the first level of appeal, and you have a right there. And then you get to the Supreme Court of the United States, and that's the final level of appeal in the federal system, and they are not required, as I said before, for the Supreme Court to take the case. Now, when you talk about circuit courts, it used to be that judges would ride around their horses to different courts to hear cases. So there was a circuit. So basically what you have now is you have 94 district courts, which are the first instance, where you get into the federal system, into the court system. Then there are 13 circuit courts, and then there's one Supreme Court throughout the country. Now, these federal courts are all limited in their jurisdiction, right? That means they can only hear cases of a certain type that are authorized by the U.S. Constitution or federal statute. You got to remember that a lot of the court system, pretty much all of it, in Article 3, there's not a great deal of structure in the court system. Basically, they pass it along and say, hey, upon the first Congress getting together, you guys will put together the court system. And so there's a great deal of structure put in place by political entities. So the federal district court, right, is the starting point of any case that's going to go under the federal statutes. And, the federal government writes law, right, legislated by and the like. The Constitution they look at, and treaties. So this type of jurisdiction is called original jurisdiction. It comes into the federal system, and they handle it. Now, the jurisdiction of state courts can sometimes overlap with the federal courts. Some cases can be brought in both courts. They would fit in either place. So the plaintiff has the initial choice of where they want to bring the case, and whether they want to go to state or federal. Or not. If the plaintiff chooses a state court, now the defendant may sometimes choose to remove to a federal court. So where there's overlap, there's a decision where to go. The plaintiff makes the decision about where to go, or their attorneys do with their input, and then the other side can ask to remove it to federal court from the state court. So cases that are entirely based on state law can be brought in federal court under the court's diversity jurisdiction. Diversity jurisdiction allows a plaintiff of one state to file a lawsuit in federal court when the defendant is located in a different state. So what you have here in diversity, you have someone from New York and someone from New Jersey in a conflict. And since it's two different states, and you can have, or one would assume you can have, right, in one of those states, a fair hearing that you would have if there was nobody, you're not in that court system. In other words, one makes the assumption that New York is going to favor New York litigants, and New Jersey will favor New Jersey litigants involved. And so we think we really can't have that. So we need to get to some place where you have independent arbiters that are not going to be subject to the political wills of that court system in that state. So basically, that's when you have that diversity jurisdiction, the plaintiff can make a state about filing a lawsuit in the federal court, or the defendant located in a different state. The defendant can also seek to remove the case from that court. So now criminal cases may not be brought under diversity jurisdiction. Now think about why that is. Because in criminal cases, it takes place in a certain state. There's not a civil dispute between citizens of two different states. In criminal cases, the act takes place in a particular state. So if there's a murder or a robbery, even though that person lives in New Jersey but comes into New York and commits that crime, that's a New York issue, not in New Jersey, and there's no diversity, right? So states can only bring criminal prosecutions in state courts, and the federal government may only bring criminal prosecutions in federal court because it's a federal law as opposed to a state. And even if there's an overlap of those two things in criminal matters, because there is appeal up, they don't come in through federal court. It's also important here to note that the principle of double jeopardy, right, which doesn't allow a defendant to be tried twice for the same offense or charge, does not apply between the federal and state government. So what that means is that if on the state level you've been charged with something and there's been a determination, say, that you're innocent, the state brings, let's say as an example, murder charges and doesn't get a conviction. It's possible for the federal government, in some cases, to file charges against the defendant if the act is also illegal under federal law. So there, you don't have double jeopardy. Double jeopardy would mean in a court system that you're found innocent of something, say in New York, and New York comes back and charges you again. One of the reasons why you see, with someone's being charged, right, with almost anything, civil or criminal, but especially in criminal, you'll see that there's so many different charges against that person, different degrees, right? And the idea is you may not get a second bite at the apple. So, let the jury decide that in the first count, the second count, the third count, maybe the person's not guilty, but on the fourth count they are. So you want to have as much, opportunity to obviously win that case. Now, when you think about federal judges, especially the Supreme Court justices, they're selected by the president and confirmed by the Senate, with the provision the Constitution says, with the advice and consent of the Senate. And these justices can hold their positions during good behavior. Now, that means the rest of their lives. They can also be removed, as I mentioned, by impeachment. Let me explain impeachment, because I think people get very confused with it. They call the process, the entirety of it, impeachment. The House of Representatives brings up the charges, the acts they think the president or whomever, the judge, a lot of the justices, and that happens behind the scenes. It's a big deal when it's the president that's, going to be impeached. And so the House of Representatives brings up charges, and if it wins the day, gets support of the House of Representatives, there are members that go and to the Senate, and they're the ones who bring the case, so the Senate can decide innocence or guilt. If the Senate, so it's a two-part process. Impeaching the president, right, getting the articles of impeachment together, and then if it wins the day in the House of Representatives, go into the Senate and manage that case before the Senate that sits basically as a jury. Where a president's concerned, that's really difficult to pull off, only because it really affects the future of that office. In other words, you could politicize it. And it's been politicized as of late. And so we'll have to see if that begins to become the norm, in which case there's a breakdown in the system. And those that rely on that system, the average citizen, is not going to be have the kind of faith in the system that we'd like to see them have, so that, as Hegel and others have said, there's support, public support. Look, if the public doesn't support the political process and doesn't trust the judicial process to correct what that political process is doing, because it violates the Constitution, let's say, or what have you, if they can't depend upon that, then the courts are complicit. And there really is no structure for protecting the liberties and the rights of people, because the court itself is politicized. That's a real danger. So basically, throughout history, something like 15 federal judges have been impeached due to alleged, wrongdoing of some kind. So one exception to the lifetime appointment is for magistrate judges, which are selected by district judges and serve a specified term. So there's different types of judges here. Just as an aside there, just keep in mind that it's not all elected justices or appointed justices. There can be an appointment to the lower courts to handle specific cases. What about these district courts, which are the first instance, where you bring the 94 of them, where you bring, your issue? These are the trial courts where trial takes place in the federal system, right? And each district court has at least one United States district judge. Obviously, the more population in the state, the more this changes. So, again, they're appointed by the president, these justices, and with the Senate, you can get a life term. So district courts handle trials within the federal court system, both civil and criminal, right? The districts are the same as those for the U.S. attorneys, and the U.S. attorney is the primary prosecutor for the federal government in this or her respective area. So it makes sense. There's 94 of these courts, and you have to have justices that hear cases in those courts. Obviously, there are 94 because you're covering the entire country, and when you have more dense population, as I've said, you're likely to have more of these justices. So some tasks of these district courts are given to a federal magistrate judge. Magistrates are appointed by the district court by a majority vote of the judges and serve for a term of 8 years in full-time and 4 years in part-time, but they can be reappointed after completion of their term. All right, all that being said, some of us have been at traffic court, and there's someone that's called the judge there. But that's not really the case. They have power, but it's not the same. So federal trial courts also have been established for a few subject-specific areas. Typically, a particular subject area is so specialized that you need the judicial process, to set that aside as a special instance and have people that adjudicate, that understand the technicalities in that area. So each federal district also has a bankruptcy court, for example, and those proceedings take place in that court. But there's not really a judge. You have someone overseeing it, an administrator, if you're a magistrate, just to move the thing through. Now, additionally, there are some courts have nationwide jurisdiction for issues such as tax. United States Tax Court, claims against the federal government, which is the United States Court of Federal Claims. You're suing the federal government. And international trade. There are also military courts and the like that deal with particular, military breaches of, the law, would have a military law. These circuit courts, once the federal district court has decided the case can be appealed to these United States Court of Appeals. There are 12 federal circuits that divide the country into different regions. The Fifth Circuit, for example, includes the states of Texas, Louisiana, and Mississippi, those 3 states. Cases from the district courts of those states are appealed to the United States Court of Appeals for the Fifth Circuit, which covers those states, which is headquartered in New Orleans, Louisiana. That's not so important. Where it's actually centered, it goes back historically, but at the end of the day, what matters is they belong to the Fifth Circuit. That's where the appeal goes in. Additionally, federal court, Circuit Court of Appeals, has a nationwide jurisdiction over very specific issues such as patents. Patents are very special. Even if you go to law school and you're interested in patents, you need to understand the math and the science behind things. And so that means the justices that are sort of on the court and the lawyers have to be well versed in that particular area. Otherwise, what do you have? You have a bunch of people hearing cases that they may not understand the particulars of. So, so each circuit court then has multiple judges, ranging from 6 on the First Circuit to 29 on the Ninth Circuit, right? And again, that has to do with population, the number of cases. So circuit court judges are appointed for life for the same reason, political, being removed out of the political arena by the president, confirmed by the Senate. That's usually the case, especially with life appointments. It is the case. And any case may be appealed to the circuit court once the district court has finalized its decision. And then some issues obviously can be appealed before a final decision by making an interlocutory appeal. You don't need to know what that is, just for now. So appeals to circuit courts are first heard by a panel consisting of 3 judges in the circuit court, and then parties file briefs to the court, to the circuit court appeal, arguing why the trial court's decision should be affirmed or reversed. Obviously, the losing side wants to have it reversed. The winning side wants it affirmed. After the briefs are filed, the court will schedule oral arguments. This is when it's up to the appeal level in the circuit, in which lawyers come before the court to make their arguments and answer the judge's questions. Typically, the judges have made up their mind in reading all the motions and the like, but they want to ask questions for 2 purposes: clarify anything that they have an uncertainty about, but also to try and convince the other justices that, given this information, they should join them in the decision. So, although it's rare, the entire circuit court may consider certain appeals in a process called en banc hearing. Like the Ninth Circuit has a different process for en banc than the rest of the circuits, where there's no jury, it's just the judges making that decision. En banc opinions tend to carry more weight and are usually decided only after a panel has first heard the case. So you've got an appeal that's being basically coming before the justices, and they make a decision about, what is and what is not within, what they decide is a violation or not a violation. Now we get to the Supreme Court. So it's district courts, first instance, it's the appellate, circuit courts, and then some cases can be called up by the Supreme Court of the United States, typically because the lower courts seem uncertain about how to apply the rule or what it really means. And so the Supreme Court wants to make that clear, because as you'll see with the rule of law, having a level of certainty and clarity around something is critical to the legal process, because without it, you can't claim that the judicial process is fair. All right, so the Supreme Court of the United States is the highest court, as I've said, in the American judicial system, and has the power to decide appeals on all cases brought in federal court or those brought in state court dealing with federal law. So if a First Amendment freedom of speech case decided by the highest court of a state, usually the Supreme Court, doesn't have to be called that, the case could be appealed to the federal Supreme Court, what we think is the Supreme Court of the United States, right? We don't think of it, it is. However, if that same case were decided entirely on a state law similar to the First Amendment, the Supreme Court of the United States would not be able to consider the case, which seems odd, right? So after the circuit court or state Supreme Court has ruled on a case, either party may choose to appeal to the Supreme Court. Again, they have no right automatically due to appeal to the circuit. But going beyond that to the Supreme Court depends upon the Supreme Court taking the case. If you think about the NAACP, and when Thurgood Marshall was heading it, they realized they needed to get the court accustomed to hearing these cases. So they brought up cases they pretty much knew they were going to lose, but they made their arguments. And then came along, Brown versus the Board of Education, and what you have is you have the court now ready to hear. And that case overturns Plessy, which happened several decades before, around the idea of separate but equal. Okay, and we'll talk about that more later on. All right, so the Supreme Court, again, is the final arbiter of the law because they make a decision on that level, and the Constitution, it says it's basically the final law of the land, so that's where we're at. All right, so basically, the court, the members of the court, the justices, right, like other federal judges, are appointed by the president, confirmed by the Senate, and so on. There are 9 justices, you probably know that, on the court, 8 associate justices, and 1 chief justice. Now, that's a little bit misleading. The associate justices are not on a lower level than the chief justice. The chief justice is basically the administrator of the court, dealing with the everyday sort of stuff. So the administration of the court, and the president chooses who the chief justice is going to be if there's a vacancy. They just basically hand the administration stuff. They have no more sway in the decision or even writing the decision than that justice, the Chief Justice of the Supreme Court. Okay, so we did that already. Okay, hold on. All right, here we go. So when we talk about investigation, going back and thinking about it, there are any numbers in the federal, any number of institutions in the federal system that are instigatory, right? So, Federal Bureau of, the FBI, the DEA, the Drug Enforcement Agency, the Bureau of Alcohol, Tobacco and Firearms and Explosives, the ATF, the United States Secret Service, and Homeland Security investigations. The investigators of all those agencies investigate the crime and obtain evidence, and we'll talk about evidence in a minute, and help prosecutors understand the details of the case. Remember, the prosecutors don't have to take it. The prosecutor may work with just one agency, the FBI or whatever, but many times it's several investigating agencies are involved, typically because you want as much evidence as possible. So part of the investigation may involve a search warrant issued by the court. Now, the Fourth Amendment of the Constitution usually requires that police officers have probable cause before they search a person's home, their clothing, car, or other property. So these searches may typically require a warrant issued by a neutral detached judge. No skin in the game. Arrests also require probable cause and often occur after police have gotten an arrest warrant from a judge. Now look, probable cause means you've got an argument. There's a cause for action, or so they believe, that something has happened. They can't just go around arresting people willy-nilly. They've got to basically say that, we can demonstrate that there is some connection between the incident and this person. Now, there's different types of evidence. And again, these are infused with judicial decision in the process. Direct evidence. Now, look, a prosecutor evaluates a case and uses all the statements and information they have to determine if the government should present the case to a federal grand jury. That's basically, there's a level of secrecy there. The facts, the jury, between regular people, they make a decision about the specific person or persons who committed the crime. Do they think there's enough evidence for them to move ahead, the government to move ahead, and charge this person? So before the prosecutor made any conclusion, they have to look at both direct and circumstantial evidence. So direct evidence is evidence that supports a fact without inference. Direct evidence means that, that person saw or, firsthand, they're an eyewitness, to a crime, and that would be considered as an example direct evidence because the person actually saw it, the crime itself. Testimony related to something that happened before or after the crime, right, would be considered circumstantial. Now, here's what's important to remember. People's recall is not very good. So it's interesting. Eyewitness testimony is not really reliable. It's odd, right? But people perceive things differently, and their memory of it changes. So testimony that's related to something that happened before or after the crime has to be circumstantial because they weren't there. They didn't see the crime. The guy committed the crime. They didn't see it, but he came into a bar where they were, and and they were bragging to this person about this robbery or whatever the case may be. That's circumstantial evidence. That person didn't see it. That person's just reporting it. So the second type of evidence is circumstantial evidence statement, or information obtained immediately or indirectly, I should say, not based on first-hand experience or knowledge by a person. That's evidence includes impressions about an event that happened which they didn't see. Now, circumstantial evidence is not as strong as direct evidence, because direct evidence you have information and you witness a crime. And so there, it has more value because you're actually reporting at a scene. Where, for example, hearsay is just, someone told someone, and that's very weak because someone told you something, and that person that told you, how knowledgeable were they of what occurred? So the prosecutor in charging, in a criminal case, studies the information from investigators, right? And the information they gather from talking with individuals that are involved. The prosecutor decides then whether to present a case to the grand jury. Now, that process can be very easily corrupted. That's to say that the prosecutor could say, "No, I don't want to take on this kind of a case." So no one asks, "Why didn't you prosecute?" Other than maybe the media, and then typical response is there wasn't the evidence we needed to prosecute effectively, so we didn't do it. So when a person is then indicted, right, they're given formal notice that is believed that they committed a particular crime. They believe. They can't say there's guilt because that's for the court to decide and the jury. So the indictment contains the basic information that informs the person of charges against them. So for potential felony charges, a prosecutor will present evidence, and this is all part of the process, right? To an impartial group of citizens called the grand jury, and I've already mentioned that. So witnesses can be called to testify, evidence is shown to the grand jury, and an outline of the case is presented to the grand jury members. Now the grand jury listens to the prosecutor and witnesses and then votes in secret on whether they believe that enough evidence exists to charge the person with a crime. Prosecutors don't want to, get a grand jury together if they think they haven't got a strong enough case, because you don't want to sort of reject it at that level. So a grand jury can decide not to charge an individual based on the evidence, and no indictment would come then from the grand jury. And all proceedings and statements made before the grand jury, as I mentioned, are sealed, and the only people in the room when they deliberate who have knowledge about who said what about whom, right? So the grand jury is a constitutional requirement for certain types of crimes, meaning it is written in the United States Constitution. That's what we mean by it's required. So that group of citizens who do not know the defendant can make an unbiased decision about the evidence before voting to charge an individual with a crime. So a group of citizens, which is the grand jury, who do not know the defendant, right, can make an unbiased. If you know the defendant, obviously it's going to be biased. So grand juries are made of approximately 6 to 23 members. Their proceedings can only be attended by specific persons. For example, witnesses who are compelled to testify before the grand jury are not allowed to have an attorney present, right? They want to know the facts, and at least 12 jurors must concur, agree in order to issue an indictment. States are not required to charge by use of a grand jury. It's different for the federal government because it's in the Constitution. Nothing affects the states, but many do. Why? They want to know how strong a case they have before they bring it before a jury. So that's one good reason for doing it. And also federal misdemeanor charges don't have to have a federal grand jury. The misdemeanors. Venue is important, where the thing takes place, where in the process, physically, does the case get heard. So we talked about diversity jurisdiction, but there are other reasons why besides diversity between people from different states or what have you, that a case might be in a particular venue. The most obvious one is the location of trial is in federal cases are tried in United States district courts, 94 of them. There's 94 of these district courts, including the Colombian territories. Many states have more than one district court, so the venue will depend on where you live in the state. It's really mostly about getting to a place and being able to make your argument. And so it's, the venue is usually whatever district court is closest. Now, the initial hearing and arraignment are the same day or the day after the defendant is arrested and charged, and that's not always the case. They're brought before a magistrate judge for an initial hearing on the case. At that time, the defendant learns more about his rights and the charges against him. They're told, right? So they know. Arrangements then are made for what? For him to have an attorney if they can't afford one, and the judge decides if the defendant will be held in prison or released until trial. Now, this is key. We're going to hold this person. They've not been found guilty, but we're going to hold them in prison until the case comes, which could be months and months and months away, even though it's supposed to be a speedy trial. That's up for grabs. In many cases, the law allows the defendant to be released from prison before a trial if they can meet the requirements of bail. Now, that's today a very controversial thing. Should there ever be bail? Right? Bail is where you're paying, there's a bail fee, and you pay a percentage of that. And the idea is that will, if you don't come to court, you forfeit that. And it's a means of getting people into court. Of course, if you don't have a whole lot of money, you may not be able to meet bail, and you just wait for your case in prison. Before the judge makes decisions on whether to grant bail, they hold a hearing to learn the facts about the defendant, so they know whether level of bail or whether or not they should allow for bail. How long has the defendant lived in the area? That's important. If they have family nearby, because people tend to stay close to their family. Is there a prior criminal record, right? Because if there is, that may be germane. They say, look, this person keeps committing this crime. We don't want them out there. And also, if they have threatened any witness in the case, we don't want them out there. So the judge also considers the defendant's potential danger to the community. And lately, there's been people that have been released and have committed additional crimes, and that's one of the arguments against, not offering bail but keeping people in prison. So if the defendant can't post bail, pay the money, the judge may order the defendant to be remanded into custody of the U.S. Marshals pending trial. So you could sit there for a while. The defendant will also be asked to plead guilty or not guilty to the charges. All right. Then step 4 in this process is discovery, right? Before the prosecutor begins a trial, they have to do a lot of work, right? The prosecutor has become familiar with the facts of the crime, he's talked to witnesses, studied the evidence, anticipated problems that could occur in the court and that arise during trial, and the strategy they're going to take. Right, this is all important during the discovery process. You're discovering, the facts that you need. Meanwhile, in the process and what you should do, planning your attack, if you will. Meanwhile, the defense attorney is preparing the same way. Now, one first step in preparing for trial is talking to witnesses, we've said, who could be called in to testify in the court. Now, a witness is a person who saw or heard, this is direct now, the crime taking place or may have important information about the crime or the defendant. When we say, saw or heard the crime, you don't always see a crime. A crime could be happening behind closed doors, but you hear it. It comes down to 3 types of witnesses, right? A lay witness, which is the most common type of person who watched certain events and describes what they saw. An expert witness, and usually both sides call experts, want to negate each other, is a specialist, someone who is educated in a certain area. They testify with respect to their specialty area only. I hate to go back to the O.J. Simpson trial, but there were experts on both sides, and the way in which his defense team, O.J. Simpson, handled it was to actually muddy the water so much that the jury couldn't understand it. Couldn't understand the expert. Then there's a character witness who's someone who knew the victim, the defendant, or other people involved in the case. Character witnesses, they usually don't see the crime take place, but they can be very helpful in a case because they know the personality of the defendant or the victim, or what type of person the defendant or victim was before the crime. Neighbors, friends, family, clergy are used as character witnesses. Look, someone can go momentarily insane. Someone walks in on their partner engaged in some sort of sexual activity with someone else. There could be a moment where that person, is not capable of managing their emotions and does something that's outside the character of that individual. And the courts would want to know that, right? So the prosecutor talks to each witness to avoid any surprises, obviously, and to figure out what they might say during trial. All right, another important part of trial preparation is reading every report written about the case based on the information. Prosecutors have to provide the defendant copies of materials and evidence that the prosecution intends to use at trial, and this is called discovery. They can't hide information that they know, especially if it's exculpatory. In other words, the evidence on the side of the government charging has some evidence that really would very clearly say this person did not commit the crime. If they hold back on this and it's ever discovered, a new trial will be demanded, or if it's if it's exculpatory, the courts will just dismiss it. So if it's exculpatory, they're going to get rid of it. So you have to show the defendant's innocence. Now the next step is plea bargaining. This is when the government has a strong case, and the government may offer the defendant a plea, plea deal to avoid trial and perhaps reduce his exposure to more lengthy sentences, as I've already mentioned this. So a defendant may only plead guilty if they actually committed the crime and admit to doing so in open court before the judge. They want that person not to be influenced. They want that person not to say, they're guilty behind closed doors. In open court, they have to say they're guilty. And then we go from there. Then we have the sixth step, which is a preliminary hearing. Once the defendant has entered a plea of not guilty, a preliminary hearing will often be held. If they're guilty, there's no need to move forward with all of this. They've admitted guilt. The prosecutor must show that enough evidence exists to charge the defendant. Preliminary hearings are not always required, and the defendant can choose to waive it. Okay? It must be held within 14 days of initial appearance. If the defendant is being held in jail, if the defendant is out on bail, it must be scheduled within 21 days of the initial appearance. And the preliminary hearing is like a mini trial. Everyone's going to see how this thing is going to work out. What they have each side, and what's going to more than likely be the way in which they have to approach it. So the prosecution calls witnesses and introduces evidence, and the defense can cross-examine witnesses. However, the defense cannot object using certain evidence, and in fact, evidence is allowed to be presented at a preliminary hearing that could not be shown to a jury or a trial, right? Because you're trying to figure out whether you're going to move forward or not. If the judge concludes there is probable cause to believe the crime was committed by the defendant, a trial will soon be scheduled. Then step 7 is the pretrial motions. Now here, it's one of the last steps the prosecutor takes before a trial to respond to file motions. A motion is just an application to the courts made by the prosecutor or defense attorney requesting that court make a decision on certain issue before the trial begins. The motion can affect the trial, courtroom, defendant's evidence, or even the testimony. It's convincing the judge, this is what you should allow, this is what you should not allow. Only judges decide the outcome of the motions. So common pretrial motions include the motion to dismiss, makes sense. The defendant wants the case gone. Motion to suppress, an attempt to keep certain statements or evidence from being introduced as evidence. And motion for change of venue. We talked about venue already. May be made for various reasons, including pretrial publicity. So he's supposed to be tried in this district court. But everybody knows the case in that area, and it's felt that the defendant cannot get a fair trial because everyone's already made up their mind. The media, everyone else, this person is guilty. Step 8, of course, is we go to trial, and the trial is structured in such a way that, the judge is impartial, and the jury they select is impartial. And jury selection at trial is really a defense attorney does the selection of jurors in the case, both the prosecutor, and the defense attorney. During voir dire, which is what it's called, usually both sides are allowed to dismiss a certain number of jurors without cause. And basically, 12 jurors are selected randomly and from the jury pool. A list of potential jurors is compiled, and we're off to the races. All right. Last few things. Opening statements. Opening statements are allowed. The prosecutor and the defense attorney briefly tell the account of the events. The statements usually are short, like an outline, and don't involve the witnesses or any evidence. The prosecutor makes an opening statement first. The government has the burden of proving the defendant committed the crime. And then there's a presentment of the cases, the witnesses' examination, and basically the government rests, or the defense has the opportunity to present witnesses' evidence to the jury. And then there are objections during direct or cross-examination. Now, either attorney can make an objection to a question or a piece of evidence to the judge if someone's beyond the knowledge of the witnesses, or arguing with witnesses rather than asking questions. It's argumentative, they'll say, right? Or the witness is not an expert in the area and shouldn't be allowed to say certain things or testify. Typically, things are relevant to the case. They'll object relevancy. This is not relevant. Why are they asking this question? Common objections also include things like hearsay. This is hearsay, which is secondhand information. Relevance, right? Testimony and evidence presented at trial must be relevant to the case. And they'll object relevant. Your objections, this is not relevant. Again. Then there's closing arguments. The jury gets instructions from the judge, and the jury deliberates, and they announce, obviously, the verdict. There's post-trial motions, which the defendant is convinced there are several motions that can be filed after the trial is over. The common post-trial motions include a motion for a new trial. The court can vacate the judgment and allow a new trial. This is rarely granted because typically the jury and their decision is respected. If the interest of justice so requires, they'll go ahead and do it, though. The motion for judgment acquittal, court may set aside the jury's verdict and allow the defendant to go free. And motion to vacate, set aside, or correct a sentence. That's often successful for the purpose of correcting a clerical error, something like that. And then you've got the sentencing, where the judge makes a determination about sentencing. And there are guidelines for sentencing, that exist out there, experts and the like pull them together. And then the judge has to make a decision. And then there's always the appeal, which is the last part of this, to the circuit court. And then it may or may not go to the Supreme Court. Okay. All of that is part of the judicial process, right? Everything there, what we think, what the purpose is, separation of the political interest, respecting the court decisions, looking at how the court proceeds. Okay, that's the judicial process in terms of its fundamental structure. But underlying all of that is the general rule, or the rule of law, which is critical because the rule of law, as you'll see in the next two lectures, really determines the validity of the system and, why the rule is so important, which is critical, obviously, as I've said, it's important to the entire process. You take the rule of the law and you do not apply it, and all of this process doesn't mean anything. And the political aspect has been introduced. And if anything destroys destroys public confidence is the loss of court's control and the ability of the court to stay free of any kind of political influence. Okay, that ends lecture 3. We're going to move on to the rule of law in the next 2 lectures. Hopefully I'll be able to fit all of that in just 2 lectures. And then you should be ready to use this information for a midterm exam.